So, in summary, I believe, and this is pre corona, I believe court systems around the world are pretty much broken. They're wonderful for the very few people who can afford the services, but for most people, they're simply not accessible.
Today on LawNext, a conversation with Richard Susskind, an internationally recognized speaker and author on the future of legal services, and an author and editor of numerous books, including his most recent, Online Courts and the Future of Justice. This is Bob Ambrogi, and you're listening to LawNext, a podcast that features the innovators and entrepreneurs who are driving what's next in law. We'll get to today's interview in just a moment, but first, let's hear from the sponsors who generously support LawNext. And now, on to this week's interview. Richard, welcome to LawNext.
Bob, it's great to be here, albeit under very strange circumstances.
Well, very strange circumstances indeed, and I hope this finds you and your family well.
Yeah, likewise, and to all our listeners as well.
Where are you sheltering in place? Are you in London somewhere? Or?
Just in the outskirts of London, within about 20 miles of the city, but we've been hunkered down for almost 4 weeks now.
Yeah, it gets old.
Although I should say, I actually work from home. So I have my study at home and I've worked from home for many years yet. So it's less of a disruption for me than for others.
Yeah, I'm in the same boat. I largely work from home. I have an office I go to occasionally. Not occasionally. I go fairly regularly, but more to get out of the house than for any other reason. I don't really need an office. But Richard, you've been writing about the future of legal practice for some 3 decades. What do you make of this moment we, the legal profession, find ourselves in right now? I mean, how does this change, if at all, the trajectory for the profession?
I think it changes it fairly radically. I've always said there were 3 factors that would bring about great change, a transformation in the legal world. The first was what I call the more for less challenge, broadly speaking, massive pressure and costs. Secondly, new providers in the marketplace like the Big Four. And thirdly, technology transforming laws is transforming so many other sectors. But I think I need to add a fourth now, and that's the coronavirus, which is accelerating many of the effects that I and others have expected for the legal profession over the past few decades.
There are many who say that in just the last 3 weeks, the future has arrived, and it's arrived with it's kind of a cold slap in the face for many. Do you think that's a fair analogy? Are we suddenly, has the legal profession been suddenly thrust into a future it wasn't quite ready for?
I think we have to be careful about the predictions we make on the back of this. People say we'll never go back and the changes are irreversible. But we have to be clear about the kinds of technologies that have been engaged. We've certainly seen that legal services and court services can be delivered differently. But we can't conclude unambiguously from what we've seen so far that working online in a variety of ways is better in all cases. I think the heart of this is that the way in which the profession has embraced technology has been largely about different ways of communicating, collaborating, video conferencing, and the rest of it with their clients. What we've not seen is the fundamental change, again, that I've discussed in relation to technologies, for example, like artificial intelligence, where we can anticipate, I think, in the coming decade, that legal tasks themselves will be undertaken very differently. So in other words, the one-to-one consultative advisory model for the delivery of legal services has been maintained through the crisis. It's just we haven't had face-to-face meetings. We haven't had appearances in court. We've been using video conferencing and telephone conferencing as an alternative to the way in which we convene. And we've been using a whole bundle of other systems and software to help us collaborate and coordinate more effectively.
So we're changing the way we meet, but we haven't really changed what we do when we meet?
I think that's right. We've streamlined and optimized the traditional way of working rather than fundamentally transforming that way of working. And that, for me, will be the story of the 20s. So certainly our minds have been opened to the ways in which technology can far more pervasively be used. But I think it would be wrong to assume that the transition from pre-technology to technology operations for the legal world has now been made.
I want to get to talking more specifically about courts, since that's been a lot of your future in the last couple of years. But I wanted to ask, just generally, with regard to law firms, are there firms that are more or less likely to get through this unscathed, and what do those firms look like?
I think many firms will struggle in terms of liquidity. I think many firms, as we all know, the model of many firms is to eat what you kill, and profits are taken out. There's very little in reserve. And there are a good number of firms that can't survive many months without significant fee income. So I think the firms that have been more prudent, the firms that have put aside money for a rainy day, are those that are more likely to survive. The very large firms, it seems to me, that are highly profitable will enjoy, as often happens, I thought we saw in the last recession, this flight to quality. But I think there'll be a good many large, medium-ish firms and indeed small practices that will suffer.
Does it matter the degree to which a firm was already using or adopting technology in their operations?
I think there will be very few firms who won't, in one way or another, manage to go mobile or at least home working fairly quickly. That, for me, is not the issue. It's just that the market for legal services over the next few months will diminish fairly radically. There'll be less deals to be done, less disputes in courts. There will be an upsurge in some areas like contract review and employment law and so forth, but not enough to make up for the great loss that there will be. So I think most firms that I'm speaking to are anticipating a fairly patchy few months, and that's why people are looking to offer sabbaticals. They're taking reductions in drawings, and unfortunately thinking of letting people go as well. So I think there just won't be enough legal work to go around for a while. On the other hand, I suspect when the economy returns, as inevitably it will, there'll be an upsurge for a while. There'll be enthusiasm within the economy and more work to be done.
Is there an upside in any of this for law firms? Is there an opportunity for them here?
I'm very reluctant to speak of opportunity at a time of such tragic loss for so many people, but it is the case that many of the hesitations that people have had about looking to the possibility of using technology more extensively, these hesitations have had to be overcome. I think as you look in the past, the technical obstacles have been far fewer than the cultural obstacles to change. For one reason or another, many lawyers have enjoyed working the way they always have done. I always say, lightheartedly, but to the very profitable firms, it's hard to convince a room full of millionaires that they've got their business model wrong. And I don't think the business model's fundamentally changed, but there's certainly been eyes open to ways of interacting with clients in new and more imaginative ways.
You recently published a book, Online Courts and the Future of Justice. In the introduction to that book, you talk about your granddaughter, born 2 years ago in 2018, and speculate that when she turns 21 in the year 2039, she might wonder why her grandfather bothered to write a book about the need for online courts. But then you go on to say, and this is a quote, "But in 2019, as I write these words, many lawyers and judges are skeptical." Would you write that sentence today? Do you think what we're going through right now has perhaps erased that skepticism about the need for online courts?
I think that many judges have been amazed at the extent to which they can hold satisfactory hearings on an audio or a video basis. It's not the fully online courts, the full version of online courts that I have in mind, but we're certainly far more rapidly than I could have anticipated on the journey towards taking courts out of physical buildings into electronic environments. In the book, I asked the question, is court a service or a place? Do we really need to congregate physically to solve all our differences? Or might we be able in the internet world to harness the power of technology to allow people to come together and virtually sort out their difficulties? And I have in mind, as I say, a more advanced conception of the online court. But what we've seen in a fortnight, rather than perhaps the decade I was anticipating, in a fortnight, we have seen huge numbers of courts around the world shutting, and we have seen correspondingly large numbers of cases being held by video conference and by telephone conference too. And that takes us well on the road towards a fundamentally new way of looking at how it is that people's disputes can be resolved publicly.
You have, in fact, launched a website called Remote Courts Worldwide, which is remotecourts.org, and where you are tracking many of these developments with courts globally.
Yes, just a little bit on terminology. We chose, certainly in England and Wales, the term remote courts as a distinct entity from a physical court. But there are three different forms of remote court that we're seeing today. One is the audio court, or the audio hearing, where hearings are held by telephone, fundamentally. Secondly, there's the video hearing, where you use Skype or Zoom or the rest of it for some kind of hearing. And thirdly, there's the paper hearing, which is not in fact a hearing at all. That's where judges receive the arguments and evidence in electronic form, and on the basis of the papers alone, come to their decisions and deliver them back to the parties in kind. I think it's important also to say of the audio and video hearings, there's two sorts. There's the kind of hearing where there is a physical hearing and some participants are engaged either by audio or video. And then there is the kind of hearing where there is no physical hearing and everyone is connected electronically either by audio or video. But the thought I had as I saw and was advising on the courts in England moving to physical to remote approaches was that this must be happening around the world. So we had the idea of setting up a website, as you say, remotecourts.org, where we could invite countries around the world simply to offer us links to news of what they're doing in different countries, the experiences they have, the insights they have enjoyed and so forth. And this is, I think we've already got more than 20 countries contributing. What is amazing, and for me completely amazing, is that in a short number of weeks, we are seeing this remote use of court service or remote courts in a way that really was barely imaginable, certainly the scale we're seeing it today, 3 months ago. So when I wrote my book, Online Courts and the Future of Justice, I really had no sense at all that so many of the ideas there would be so soon to be embraced.
Well, something else you wrote in that book is, with regard to the courts, is that you can't change the wheel on a moving vehicle. Is that what the courts are having to do right now? Essentially, they are.
I think this is true of law firms as well. It's easy enough, or relatively easy, when you're starting a business from scratch to think about the technology you want to use. But in a fast-moving, high-volume business, you can't just stop and graft technology on or replace fundamental technologies overnight. It needs to be a gradual process. So what I always said, the answer to the can't change the wheel in a moving car problem is you start a new car. And that takes some guts. In a law firm, it requires almost some kind of R&D capability or a new business setup. And in the courts, it involves you setting up remote courts or online courts. Now, no one was going to do that quickly last year, but most jurisdictions have done it quickly this year. So it's the moving car is moving at, frankly, a far slower pace, and gaining pace in the outside or inside lane, whichever jurisdiction you work in, is this whole idea of remote courts, of online courts.
Richard, you wrote recently an essay about this in the Times of London, in which you said that for you, it's reassuring, for you in the UK, it's reassuring to have leaders in the judiciary and government who have for years been supportive of virtual courts. That's not necessarily true in other countries, and I don't think it's true universally here in the United States. Certainly, there have been pockets of leadership on that issue and innovation on that issue. But if you were to speak generally about the judiciary here, I think that they've been largely resistant, or at least at best, perhaps uninterested in these kinds of innovations. How does a judicial system such as ours in the United States that's somewhat been resistant to this start to make that, start to change the wheel on that moving car? How do we start to move beyond what have been obstacles to these kinds of innovations?
Well, under normal circumstances, it's tremendously difficult, isn't it? But currently, and there'll be a little bit of a lag here, I suspect, but currently Chief Justices and so forth, who hitherto have been sceptical, will recognise that if justice is to be delivered, if the rule of law indeed is to be observed, and we're accepting that physical courts have to close, then the only alternative will be a shift to some kind of remote or online court. And as I speak to Chief Justices around the world and observe different jurisdictions, those that have most quickly embraced remote courts and have seen that this is the route they must take have been those whose leaders have already in the past expressed interest and support for the idea. Those who've been sceptical, those who've been cynical, I'm afraid, take a couple of weeks to come to terms with the notion that life must be conducted very differently indeed. But I've no doubt, kicking and screaming perhaps, most senior judges around the world, if indeed we're locked down for many more weeks as I expect we will be, most senior judges around the world will come to acknowledge that, as I say, if we want to offer access to justice, we need to do so through audio hearings, through video hearings, or through paper hearings.
We'll get back to my interview in just a moment, but first, let's take a break to hear from the sponsors who generously support LawNext. And now, let's continue this week's interview. In your book, you outline your vision for online courts. You talk about your vision of an electronic court system that is as easy to use as Amazon. What is your vision for that, and how did you come to formulate it?
Well, the vision came to mind over a period of years and working with others. For me, in 2014, I was asked by a body in England called the Civil Justice Council that looks to the future of our justice system, supported by the government and the judges. And we were asked, or I was asked, to put together a group to advise on the use of online dispute resolution in the English justice system. And ODR, online dispute resolution, had been around for many years, and I had been interested since the 90s. But we quite quickly came to the conclusion as a group that the theme we were expected to follow was this, that there was this thing called ODR, which is really a form of electronic ADR, an alternative to the court system, that this ODR business was moving rather quickly, and there must be a possibility, many judges and senior officials thought, of taking cases out of the court system and resolving them differently as a form of ADR. But we thought the reverse. We said, if there are these exciting new ways of resolving disputes, surely they should be part of the court system rather than an alternative to it. And as we looked around the world, really the only people at that stage who were thinking similarly were the people in British Columbia, Darren Thompson and Sharon Salter, who were looking for their civil resolution tribunal, which they set up in 2016. So the idea for us was actually to use this technology as part of the court system. And the fundamental idea was online judging. And this is where it's slightly different from what we're seeing just now in the remote courts, because online judging is more like what I call the paper hearing. The idea here is you've got human judges making decisions not on the basis of a physical hearing or a virtual hearing or an audio hearing or any of that, but actually on the basis of submissions and evidence put to them electronically, and the judges, human judges, respond, deliver their judgments. There has never been any oral evidence. It's all done in the papers alone. So that's the fundamental model of online judging. Not suitable for all cases, we acknowledge, but particularly for low-value disputes, we felt this would be a more proportionate way of resolving these difficulties. But the story didn't stop there for me. Over the years that followed, I came up with the idea of what I called the extended court, and this is the second component. And the line of reasoning I follow is this. One of the difficulties we have around the world is that most people in our world sadly can't afford access to formal legal advice and representation. And so it seemed to me that it's not enough for an online court to offer dispute resolution services, which is, of course, its primary purpose, but I argued for a secondary purpose, which is helping people understand their own rights and entitlements, helping people understand the options available to them, helping them formulate their arguments and evidence, helping them run through the system, as it were, without representation. And this I call the extended court. And so you bring these two together, human judges deciding cases in the papers alone, with lots more help provided, decision trees, flowcharts, guided pathways for the user, and we have a very different and far more accessible justice system. This all against the backdrop of some fundamental problems. According to OECD figures, only 46% of people in our world have or live under the protection of the law, the courts, and lawyers. In some jurisdictions, the backlogs in the court systems are unbelievable. 100 million cases in Brazil, 30 million cases in India. And even in countries that would claim to be advanced in their legal systems, the reality is for most users of the justice system, the system costs too much, takes too long, is intelligible only to lawyers, and somehow is just out of step in the digital society. So in summary, I believe, and this is pre-corona, I believe court systems around the world are pretty much broken. They're wonderful for the very few people who can afford the services, but for most people, they're simply not accessible. So that's why I was driven to come to write a book on online courts and underpin it with some thinking about what it is that we think we expect of a justice system.
Well, I mean, so do you see online courts as a way of bridging that gap in access to justice? Will those who are not well served by the system now be better served by an online court system?
This is precisely the aspiration. And you put it very well, because I think there is a gulf that needs to be bridged. And one way of looking at the gulf is the gulf between understanding the law and enforcing your entitlements. Because many people who've addressed the access to justice problem over the years have said the answer is a website that can tell you your entitlements, or the answer is students working in clinics, or the answer is pro bono legal service, and so forth. But a lot of these services simply help people understand what their legal position is, but don't give them the bite or the teeth of having a lawyer representing you in court. It's a little like being given a medical diagnosis, but there being no surgical or medical care available. And so we need to move beyond solutions to access to justice that help people understand what the law is to some kind of system that offers the threat, frankly, of the coercive powers of the state, because that's what it is that often encourages people to come into line. And today, the only way of invoking the coercive powers of the state is by and large through the use of lawyers and physical courts. And I'm saying that's how the gap was bridged in the past between understanding and enforcement. In the future, we'll bridge that gap, I believe, or I recommend, through online courts.
Richard, you talked about this concept of online judging as paper-based judging, meaning human judges deciding matters without hearings or testimony. Why stop there? I mean, why not talk about online courts as having trials by video conference or other kinds of face-to-face taking of testimony or hearing arguments from lawyers?
Well, in a way, I think it goes the other direction. I think audio hearings and video hearings are on the path towards deciding cases asynchronously. And to use that technical term, one of the grave difficulties about traditional physical hearings, and frankly with audio and video hearings, is that all the parties need to be assembled at the same moment in time. And when our world gets back to normal, that often involves people taking a day off work, for example, for the sake of one hearing. Wouldn't it be far more convenient if you could, as with so many other communications in the internet, essentially communicate asynchronously? That's to say, like a text message, like an email, you respond or put forward your point at your own convenience. And my argument is that if a case can be resolved asynchronously, it's much more efficient and much lower cost and much less forbidding to do it in that way. But I don't think there's any single electronic version of the court for the future. I think we'll see a blend of audio and video of online courts as well. The fundamental point is moving away from this assumption that we need physically to assemble in a courtroom and have oral argument.
Richard, are there potential dangers or risks in moving to online courts for anybody involved in the court system, whether it's the individuals coming into it seeking justice, or the judges, or the lawyers, or anybody else?
I think there are many. Indeed, a quarter of my book is devoted to what I take to be the main objections to online courts and me responding. And it won't surprise you to hear that I think there are responses to most of the issues, but they are serious issues. For example, people worry about transparency and open justice. That we're used to the idea of being able to walk into a courtroom, and certainly of our reporters being able to walk into a courtroom and see justice in action. But already we're seeing, for example, in video hearings, that this is being done in action today during the coronavirus crisis. We're offering access to external parties, including reporters, into these services. Nonetheless, I do, in any event, feel that we can, in online courts, provide a more rather than less transparent service. I distinguish between what I call real-time transparency, which is the ability to observe a case, and also information transparency, which is information about cases, who's involved, what the charges or what the issue is, what the outcome is, the length of the trial, and so forth. And what we're seeing, certainly in a digital era, is a great increase in information transparency, and we're finding different ways of offering real-time transparency. So I run a series of arguments, from which I conclude at the end that actually we'll see an increase in open justice rather than a decrease. Then there's a question of whether or not a trial can be fair if you can't look one another in the eye. Somehow people may feel procedurally there's something fundamentally defective about not assembling in a courtroom. And there's been feedback, incidentally, over the last few weeks from some participants in trials that they didn't feel they got a fair hearing by appearing electronically. And again, I address these arguments largely in the context of Article 6, and it's more a European point, where fair trial, or a trial, has ordinarily been accepted by the courts as something that happens in a physical court building. So the strong precedent for fairness being somehow dependent on co-locating physically. But again, I track through the arguments and suggest through an argument or a series of suggestions about different conceptions of justice. I say that there's 7 different conceptions of justice that people invoke when they talk about online courts. And again, I argued in terms of substantive justice, procedural justice, proportionate justice, and a whole bundle of other conceptions of justice that online courts, and you would expect this, as I say again, that online courts actually will deliver a system that is, on balance, more just than a conventional system. I don't want to take these objections lightly, though, and I hope I don't in the book. That's why I devote a lot of time to them. But as a general matter, I think we have to be careful as lawyers that we don't allow, as Voltaire said, the best to be the enemy of the good. Because very often lawyers and judges, when they hear about online courts, compare what's envisaged with some kind of idealized version of the best courts as they exist today. But if you follow my arguments about access to justice, and that by and large most people can't afford access to the court system, the comparison should not be with the best courts today, but with nothing at all, which is what most people have at their disposal. So we have to be careful how it is that we evaluate and criticize. We also have to look at the court system through the lens of users rather than just the lens of lawyers. I often put this in a medical context when I say that people don't want doctors, they want health. And I think it's a kind of similar mindset's needed in thinking about courts, that people don't necessarily want lawyers and courtrooms and dusty books and wood paneling and so forth. They want their dispute resolved, or they want an opportunity to be heard, or they want to move on in life. There's a whole bundle of documented empirical studies about why it is that people go to the law, but it's not at all obvious from these studies that the only way that the needs of court users can be met is through physically congregating in a way that was frankly invented in part 900 years ago, and more remotely for most of us 150 years ago. This is the 21st century.
Certainly, one aspect of the current crisis is that your book suddenly seems far more prescient than it might otherwise have. How quickly, realistically speaking, can court systems transition from the traditional bricks and mortar model to online courts?
This takes us back to our earlier discussion and my observation that we shouldn't assume the transition from pre to technology world or legal world has taken place. We should look at what we're seeing just now as a massive pilot, as a proof of concept. But to industrialize what we have so that this kind of technology can be used day in, day out, without technical problem, without procedural hitch, in a way that can really retain the confidence of all participants, will involve many years further investment and activity. I think what we'll see now, though, and it's vital, is a willingness, a cultural shift, an appetite, both within the legal world and beyond, for working differently. So that should accelerate the process. In my book, I said the transformation should take 10 years. I could imagine it might now take 5 years, but we shouldn't think it's over.
And how do we make that transition in a way that we ensure that we are protecting those who use the justice system? I'm thinking in particular right now of you've probably heard about the experiment in the state of Utah here with the regulatory sandbox, in which they're looking at loosening regulation of certain aspects of the legal profession. And one of the key factors in that is data collection. I mean, they're going to be collecting a lot of data and measuring what's working and what's not and what the impact is. Is data collection a critical aspect here as well in terms of transitioning to online courts?
I think data collection is a critical question today, because it seems to me in this large pilot that we're conducting, we will, on a daily basis, be generating data about what's working, what's not working, how people are feeling about it, the length of hearings, innumerable data points that we should be capturing for later analysis. In the medical analogy, which unfortunately we're using a lot, we need to view some of this in the form of clinical trials. We need to think about how it is we test the various methods that we've been piloting, and we need to gather data in respect of which these tests can be conducted. So we are going to see, I hope, a whole new field of study emerging where scholars in jurisdictions around the world can take the data that we are hopefully gathering from this current experience, and in so doing can then specify the kinds of cases for which this technology works well and works in the interest of the parties, and the kinds of cases where we frankly think the interests of the parties are best protected and represented through conventional means. And although I'm enthusiastic about technology, I'm not fanatical about it. I don't think it should be used on all occasions. I simply say that I think the traditional values of a justice system, of a legal system, can often be preserved using technology. And if we can do this in a way that increases access and lowers costs, then that seems to me to be a sound policy aim. I wouldn't for a second be recommending it if I thought that the rights of individuals were impinged upon. For me, this is about increasing access. It's about creating a society where the law is available to all.
Richard, you were writing about artificial intelligence and machine learning in law well before anybody else even knew what those concepts were. What is the role of artificial intelligence in the functioning of online courts?
Well, this takes us to the second generation of AI, of online courts. What I've been talking about so far has been the first generation, online judging with human judges and the extended courts. The second generation is when some of the decisions that are made by human beings in today's system are actually made on the basis or using artificial intelligence. And you're right, I started this journey on AI in 1981 when I was a law student. I wrote my PhD on AI in law in Oxford in the early mid-80s. So I've been fascinated by this for my whole life. Just to make a couple of points clear, because lots of people want to talk about the computer judge or the robot judge and so forth. The first observation is that if what people have in mind is some kind of AI that can think and reason and work like a human lawyer, we're many, many decades away from that. Neuropsychology, neurophysiologically, we're nowhere near developing a system that can think and reason like a human judge. But you might be thinking of something rather different. You might be thinking, well, can we develop computer systems that can essentially deliver decisions with reasons? Maybe not working the same way as a judge does, but using some form of AI. But again, although there's been considerable progress in the field of AI and law, we are many years away from offering a system or providing a system that can offer, in complex areas of law, decisions with lines of reasoning. Indeed, one of the difficulties, as you'll know, with the current wave of AI that's based on machine learning is precisely that these systems are not so good at giving reasons. But we can ask a different question, and this goes back to what I call outcome thinking, which is, can we deliver the practical outcome and the emotional effects of the courts using AI, but not really modeling the process on judges? And my starting point in this is the very interesting advances that have been made in the prediction of judicial decisions by machines and using machine learning technology. And amazingly, some of these systems are performing at a very high level, and they're only going to get better. We can easily envisage the day where, for many sorts of cases, systems can more accurately than lawyers and judges predict the likely court outcome. So if you assume that that's possible, I come up with the idea of a prediction as a determination. So if you go back to Brazil and their 100 million cases in their backlog, what you would say to the parties is, I'm afraid there's a rather long queue, and your case is very unlikely to be resolved by human judges and by lawyers working in courtrooms. We have another option. All the cases in your area of law are actually in a system, and we have a system that can predict, in your particular case, what the likely outcome would be based on all these past decisions, based on the huge bodies of data we've gathered. And you could say to people, would you accept the prediction of that system? If the level of assurance is, say, 95% or higher, would you accept that as a binding determination of this court? And it seems to me that that would be a way of using AI to resolve perhaps fairly routine cases where we don't have the wherewithal, the resources to resolve them in the traditional way. But be very clear, it really isn't the robotic judge. It's using a process that's becoming quite well understood, prediction of judicial decisions, to help people attain the outcomes of the dispute resolved, and the emotional satisfaction of having the resolution behind you, of producing that in an entirely new way. That, for me, certainly in my lifetime, will be the way in which we can have AI performing some kind of judicial role.
Going back to your granddaughter, who will turn 21 in 2039, when that year rolls around, will there still be physical courtrooms? Will there still be a place for physical courtrooms?
I think for certain kinds of cases, and I certainly think for criminal cases where people's lives are at stake, whether or not, for example, there's been a murder or life sentences, for example, are being discussed, I think we are not nearly ready to take that kind of dispute from a physical courtroom to an online environment. I know our world moves on very quickly, but I'd be very surprised if all cases were online by the time my granddaughter turns 21. But I do think the great majority of cases will be conducted online. I think the high value, the socially significant, the cases where deep issues of principle are concerned, I think we may still want, as a form of public ritual, for these decisions to be made in a physical courtroom. But if you can think, as is almost impossible to do many hundreds of years from now, if you think that our machines are increasingly capable, as I think they are, they're becoming increasingly capable, our grandchildren and their children may well come to the view at some stage, if systems can overwhelmingly outperform us in coming to decisions, well, why would we want human beings involved? But this takes us into a world that's a long, long way away. I want to keep it more practical. I want to keep it more realistic. And over the next decade, I think we'll move a lot of our low-value disputes from the courtroom to online hearings and to virtual hearings. And sadly, because of the times we're living in, we're seeing that a lot quicker than any of us had expected.
Richard, I know I need to let you go, but any final thoughts?
Personal thought, really. It's a very disturbing and disconcerting time for all of us. And I just wish everyone well, a speedy recovery to those of you who are unwell, and to everyone else to stay safe, and to use this opportunity for those of you who are committed to the use of technology in the justice system to reflect and contribute. In a way, it's the war effort to see how it is that we can improve access to justice in these difficult times, because it is important that access to justice is maintained and the rule of law continues to be upheld.
Well, Richard Susskind, your book is Online Courts and the Future of Justice. I really appreciate your taking the time today to discuss it with us.
It's been a great pleasure. Thank you, Bob.